reverse inference. If one party asks for a certain witness and is not produced by the other party, say for example, if the concerned witness of the worker is within the disciplinary control of the management, it is a duty cast upon the management to produce that concerned witness. Otherwise, how is the workman to prove out his innocence? This is to be borne in mind.
Is the standard of proof required in an inquiry same as that of a criminal trial?
We have to understand this concept of the standard of proof in relation to a criminal trial, in relation to a civil trial, as well as in relation to a quasi-judicial proceeding, that is, this departmental inquiry. Now, as regards the standard of proof is concerned, one has to be very sure in mind that in a criminal trial, the guilt of the accused is to be proved to the hilt, that is beyond reasonable doubt. Now, as regards civil trials are concerned, what we see is a preponderance of probabilities, whereas in a quasi-judicial proceeding, that is this departmental inquiry, what we see is we just prove a charge under the standing orders. But however, we believe one thing, that the technical rules, say of the Indian Evidence Act 1872 or even of the Civil Procedure Code, are not at all applicable to domestic or departmental inquiries. But however, we see one more thing, that nowhere is it written or there is no prohibition in any law which says that even the substantial rules are not applicable. In fact, the management begins its evidence first, then he is being cross-examined, the concerned witness is being cross-examined by the workman. After the conclusion of the management's evidence, the worker begins, what is this procedure? This procedure is as per the Civil Procedure Code. What is applicable are the substantial rules, and what are not applicable are the technical rules. Now, this is as far as the procedural aspect is concerned. But what about the adjournments? The managements are very scared about unnecessary adjournments, because that spends time, that spends money, that spends energy, and that loosens out the case also. When are you to grant adjournments and when are you not to grant adjournments? As regards non-granting of the adjournment is concerned, well, frivolous issues, flimsy excuses, lame excuses, then don't grant the adjournment. Now, this is to be something understood by the inquiry officers also. But when are you to grant the adjournment? Say if there is a death in the family, if the concerned workman says that he is unwell, you can fall ill, I can fall ill, he is also ill today, so grant the adjournment. Say an act of God which is more legally called as vis major, a tempest, an earthquake, say the dam bursts, there is a heavy rainfall, because of which the workman is somehow held up somewhere, he cannot attend the inquiry and submits an adjournment application. In this sort of a situation, it's in the fitness of things that you grant the adjournment. These things or these procedural formalities are not to be lost into oblivion, that is, they are not to be forgotten.
So friends, in this episode, we have discussed the procedural part of an inquiry. In the next episode, we will be discussing the inquiry report and punishment.